So we've been talking about the situation with Karen Reed not only having to fight this civil lawsuit from the O'Keefe family, the O'Keefe estate, but now she's going on the offense and she filed a lawsuit against Brian Higgins, Yuri Buchanan, Michael Proctor, all the Alberts, all the McCabes. And now we're going to get a response from them basically saying, hey, what does this have to do with us? We weren't involved in this. If you want to sue us separately. Don't lump us into this entire civil lawsuit with the O'Keefe family. So we're going to see what they had to say here. And obviously we heard from Alan Jackson in an earlier video, his feelings on that. He said, either way, we going to fight this. So however y'all want to do it, fine. It just seemed like it would be easier for us to do this all in one case, because if not, we're going to have multiple duplicates of interrogatories. We're going to have duplicates of depositions. We're going to have, it's just going to take more time and it's unnecessary and a waste of the court's time. But this is what they have to say. Non-parties, Jennifer McCabe, Matthew McCabe, Nicole Albert, and Brian Higgins, opposition to Karen Reed's motion to add parties pursuant to this civil lawsuit. Non-parties and witnesses in the Commonwealth's prosecution of defendant Karen Reed, Jennifer McCabe, Matthew McCabe, Nicole Albert, and Brian Higgins, collectively the Commonwealth's witnesses, having been served by defendant Karen Reed with her motion for leave to add parties pursuant to Massachusetts Rule of Civil Procedure 21, along with the proposed cross-claim pleading, proposed claim is going to be referred to, hereby write to the court to oppose this motion. They said, we don't want to be a part of this. We already got enough issues on our own. Defendant Reed's proposed cross claims and related factual allegations against the McCabes, the Alberts, and Mr. Higgins are a vile work of fiction. Oh, here we go with the crying already. Lacking any basis in fact, evidence, or law. How about someone Googling on their own phone, how's long to die in the cold? You want to blame it on Karen Reed? Okay, cool. But ma'am, this was on your phone. And it was found that shortly before this man's body was found on the front lawn, that you Googled this. So that seems like a little bit of facts and evidence again, I'm not an attorney, so don't listen to me. Indeed, the outlandish allegations are a part of defendant's Reed scheme to defame and wrongfully malign the Commonwealth's witnesses to evade responsibility for her actions that she was found not guilty of not long ago, on the morning of January 29, 2022, and for causing the death of Officer John J. O'Keefe. What? How can they say this? They are doubling down. They must think they're invincible. Because there is no way, they've already tried it twice, that this is going to be pinned on Karen Reed. Karen Reed didn't do it. The jury's seen it 2 times. We saw it. She didn't do it. Something else happened here. And y'all could be the only ones who could be hiding the truth. Come on, man. The Commonwealth witnesses vigorously dispute defendant Karen Reed's allegations and will defend against these false claims. The Commonwealth's defense will include motions to dismiss, potential removal of these claims to federal court, oh my, as well as counterclaims against defendant Reed and third party Aidan Kearney, aka TB, we're going to call him, put some respect on his name, also known as Turtle Boy, for defamation and other torts that they have committed individually and in concert. The Commonwealth witnesses, however, should not be forced to litigate these false allegations and their own defamation claims in this pending lawsuit brought by the family of Officer John O'Keefe against defendant Reed and 2 other defendants for their role in causing the death of Officer John O'Keefe on January 29, 2022, the wrongful death action. Bringing defendant Reed's proposed cross claims into this action, along with Commonwealth's defamation and other tort claims, is procedurally improper at this stage and will substantially increase the claims, parties, and factual disputes and legal questions in this case without any evident economies of scale. Economies? Moreover, the plaintiff's wrongful death action is currently past the motion to dismiss phase, with discovery having commenced. If the defendant, Reed, is permitted to file these claims relating to her criminal prosecution in this case, The motion practice on her pleadings will likely take months. We're not going to hear about this case until next year. So what are we complaining about? Then, if the defendant Reed's proposed cross claims survive dismissal, the Commonwealth will file their own counterclaims against defendant Reed and Turtle Boy in this action. Those counterclaims could again trigger months of motion practice. As such, the current discovery schedule could almost be over before the pleadings are closed on the defendant's proposed expansion of this case. Accordingly, defendant Reed's motion should be denied, and she should be directed to file her proposed pleading, if at all, in a separate action. In that separate action, depending on what claims survive the dismissal, it may be appropriate for the parties to consolidate the cases pursuant to Rule 42 of the Massachusetts Rules of Civil Procedure. So they're saying we can consolidate this, but we just don't want to consolidate it here. Again, AJ talked about this. If this is the way you want to go, fine. It doesn't make sense. It's going to make more work for everybody else. But if you guys want to sit there and you want to sit for a deposition twice with Alan Jackson, I wouldn't want to sit for one once. Be my guest. At this time, it is too early to determine whether judicial economy and efficiency could be served by consolidation in the future. Nevertheless, it is evident that there is no basis to warrant joinder at this time, and the present motion should be denied. All right, and then we've got the factual and procedural background. We're not going to get into that because I'm not an attorney, and I'm not even going to know what they're talking about. And then as we go through here, let's see the points of their arguments, and then I'll leave it there. Rule 21 is not the proper vehicle for defendant Reed to join the Commonwealth witnesses and assert the proposed cross claims. Now, from what I do know, I do find it interesting that no one in the original lawsuit or the original civil lawsuit, meaning the O'Keefe's, was mentioned in Karen Reed's counterclaim. So again, it makes sense that they would have everything together because they're already going to be involved in this case. But I could see this going the other way based on my limited knowledge of the law and what Alan Jackson said himself. Joinder will cause delay and prejudice without any efficiency or judicial economy. That seems fair. Also, they say the Commonwealth will have substantial motions to dismiss if the defendant Reed is allowed to file her proposed cross claims in this action. So they're saying, if you're going to sue us, sue us. Otherwise, go sue the O'Keefe's. Go countersue them. Don't bring us into this. What do we have to do with this claim other than being a witness? So they also say defendant Reed's joinder strategy will prejudice the Commonwealth witnesses by likely foreclosing their right to remove the litigation to federal court. So they say they want to move this to federal court. Man, that does not sound like fun. If this motion is allowed, the Commonwealth witnesses will have to file defamation and other related counterclaims against defendant Reed and third party Turtle Boy in this wrongful death action. But didn't they threaten that they were already going to do that? So was that a pump fake? They put out a whole press release saying, oh yeah, we're going after Karen Reed. There was a whole article on it by Boston, I believe we read. So did they say they don't want to file defamation lawsuits or counterclaim that? This doesn't make any sense. Rule 42 consolidation may be appropriate between the separate lawsuits at a later time. Okay, and then in conclusion, they say for the foregoing reasons, the Commonwealth witnesses respectfully request the court deny defendant Reed's motion pursuant to Rule 21 to file the proposed cross claims in the pending wrongful death lawsuit. Signed by all them folks. Shout out to them. What do y'all think is going to happen? Again, if this gets changed, if it gets elevated to federal court, this is going to be a mess. And we're going to be talking about Karen Reed well into 2028. I want to know what y'all think about this in the comments in the chat. Does it make sense to you reading this that the court just leave it the way it is and let Karen Reed counterclaim, naming all the McCabes, all the Alberts, Mr. Higgins, and Yuri and the other MSP gang? Or should they keep it separate? And then we're going to be covering Karen Reed every day for the next 2 years. I want to know what y'all think in the comments in the